Okay, good afternoon, everyone. Welcome to this afternoon's hearing session, which is part of the public inquiry into the application for the proposed Arecleoch wind farm extension. For those of you taking part today for the first time, my name is David Little, and I'm joined by my colleague Alison Kirkwood, and we are the reporters who have been appointed jointly by ministers to hold the public inquiry and then to report back to them. I'll ask you all to briefly introduce yourself in a moment. And our hearing is scheduled to run this afternoon only, and we will take one or more short breaks at regular intervals. And I would remind parties that the hearing is being broadcast live, also recorded and retained for future viewing on our website. And please note that everyone's required to follow government guidance in relation to COVID-19, and we'll stop proceedings if we've got any concerns in that regard. When you're not speaking, please have your microphone off, and for anybody just observing, can they ensure they also turn their camera off? And I stress that regardless of our own recommendations to ministers, we need to have a set of conditions that we recommendation impose in the event that they wish to allow the application. So the fact that we're here today discussing conditions is without prejudice to our eventual recommendations and indeed to your own views on whether or not consent should be granted. So, without further ado, if we can just do some brief introductions and turning to the applicant first, Mr. Innes.
Yes, good afternoon, sir. My name is Colin Innes. I appear on behalf of the applicant at this conditions hearing session, and I'm also accompanied by Alison Sidgwick, who will be dealing with most of the planning aspects of those conditions, and she's from Stevenson Halliday and has been appearing fairly regularly in front of this inquiry, so I don't think she probably needs any further introduction. I also have two aviation specialists who, when we get to condition 5, I would propose introducing, and they're available if you have any questions relating to those matters, but I think it's probably best if I wait to that particular condition before introducing the two additional speakers that I have at that stage. Thank you.
Okay, thank you very much, Mr. Innes. As it happens, we don't have any questions in relation to that condition. It might be that others here have questions or comments about it, though, so we'll see. Turning now then to the council, Mr. Campbell.
Are you still on mute, Mr. Campbell?
Try again, I'm sorry. Good afternoon, I'm John Campbell. I'm representing the council this afternoon at this hearing, accompanied by Mr. Alistair McGibbon, who is the planning officer, from whom you've already heard, and Ms. Connie Lobban, the environmental health officer, from whom you've also already heard, in case there are any comments on, and she will have some comments, I think, on the conditions relating to private water supplies. Thank you.
Okay, thank you, Mr. Campbell. I see you're taking a lead from me in terms of forgetting to unmute your microphone, so that's my bad habit in inspiring everyone else. I
learned all I know from reporters.
Ms. Croftwaite, would you like to introduce yourself, please?
Sorry, Ms. Crosswaite, you're following suit. You need to unmute yourself?
I'm Susan Crosswaite. I haven't appeared yet, but I will be appearing on the noise inquiry next week. I'm accompanied by my witness on private water supplies, Dr. Rachel Connor, and will be participating. She'll be participating, I think, more than me this afternoon, but I have one or two things. Thank you.
Okay, that's fine. I'll turn to Dr. Connor in a moment. So I take it from that when I'm bringing you in, if you like, I'll go in the first instance to Dr. Connor, and if you've got something else to add, then just let me know that you want to intervene. Play it that way if that suits you.
Thank you.
Dr. Connor.
Hello, yes, everybody. Shane? I have nothing. To a number of.
Okay, I caught some of that, Dr. Connor. It might be that we'll ask you to turn your video off if we're having sessions. I don't know. I didn't hear a lot of that, and I think from other places, I think that might be the same. So perhaps if you try turning your video off at the moment, and then we'll see how it goes. I'm presuming you can still hear me, Dr. Connor. Is that right?
Yes, what I did say at the beginning was I hope this is better and that you can see and hear me, not like last week or the week before, but obviously it's not improved any. So yes, I hope to contribute to some of the issues this afternoon, and I will do it sitting here speaking to myself because I can't see anybody either.
Right. Well, apologies for that. You can't see us either, and that's unfortunate. Okay, and I'll come back. I'll come back to, as I said to Ms. Crosby, I'll assume in the first instance each time that you'll represent her, and then she can come in the back of any comments if you want to, if she wants to rather. And finally, then Ms. Spence. Good morning. Good afternoon.
Well, I'm here representing myself and to residents, the local residents, although I'm not on any of the committees. I'm actually on, and because the person who is the secretary of the Bar Hill Community Council felt so intimidated that she didn't want to take part in this process. I'm a professional musician, and I am finding great difficulty in the present situation of running my business, which is music publishing, and I also am a performer as well. That's me.
Okay, thank you, everyone.
David, can I just suggest if Dr. Connor is unable to see us, if she does want to attract attention, we maybe suggest she uses the chat function. Just obviously you won't be able to see her if she wants to intervene. And but have you used the chat button before, Dr. Connor? Down in the right hand corner of the screen, you can just attract David's attention by typing into that.
I can hear you, so I can shout if I need to, but I do see the chat button too.
Okay, lovely, thank you.
Yeah, that's fine. Don't hesitate just to shout out. So you'll all hopefully have seen the hearing agenda, which sets out the matters which we thought would benefit from further discussion today. Now, I was looking again at that agenda and preparing for this, and Ms. Crothwaite, your main interest is in how the conditions deal with private water supplies, and that most obviously relates to condition 36, but also you address PWS in relation to conditions 4, 11, 14, 15, 18 and 27. So I wondered whether it might be best to consider how the conditions should relate to PWS together, and to do that first, and to start off with condition 36, and then we can bring in what that means for some of those other conditions after that. I'm going to assume that people are content with that unless anyone tells me they don't think that's a good idea. Okay, that's fine. I'll take us through each of those conditions then, first of all, and then we can go into the others. Are there any other procedural issues we need to discuss before we start? No? Okay, so the first condition then that I want to talk about is 36, which is private water supplies. Although I'm going to jump back and forward a little bit between the related conditions, because I think it just makes sense to try and think of these issues together. So I'll often be referring to CD 24.2, which is the latest version of the conditions with people's comments on them, and it includes the questions that we had and the answers to those. So it'll be helpful if you do have that you have it in front of you. So firstly then on 36, I want to understand the origin of the appellant's and the council's conditions before bringing in Dr. Connor. So if I turn to the applicant first, Mr. Ennis or Mr. Sidru, does your wording come from the set of model wind farm conditions, which I understand is the Energy Contention and/or Heads of Planning Scotland keeps? Is that where your wording comes from?
Yes, sir, it does.
Okay, and as for the council's wording of that condition, bear with me while I just get it up on my screen. So, yeah, is that a standard one for wind farms which the council uses, or is it being drawn up in response to this development in particular?
I understand it's been drawn up for this development, but I defer to Ms. Lobban on this one.
Hi, am I looking at the number 36 is SEC preferred wording? Is this what we're referring to, the document? Because I don't have any CDs, right? Then this is the conditions we put towards the wind farms. And also, if there's anything in particular with the particular wind farms, I'll put that in specific to the application if necessary.
Okay, that's fine, but it's I'm aware councils will have standard conditions on a whole range of things, and this is the one that you would typically use for wind farms, albeit you sometimes will add bits and adapt to circumstances. Yeah.
Yes, if there's certain points we need to raise or look at in depth, then we'll highlight those, or if we feel there's further information, etc., required, then we'll highlight that also. But yeah, in the main, it's what we ask for wind farm conditions.
Okay, so the applicant says that much of what you asked for has already been provided through the EIA report. So without going back in detail over the ground we covered in the first week of the inquiry, I'm interested in whether this is new information you're seeking, or is it material that you've seen but aren't satisfied with at the present time. So I want to just take it bit by bit, and then I will bring in Dr. Connor in terms of the suggestions that she's made. So if we just look at indeed what it says is SEC preferred wording. So the first thing I want to talk about, it says it's talking about mapping all private water supply user properties, the private water supply source, uptakes, and catchment areas. So that's right. You want all of those to be mapped. The condition doesn't say what area you expect that to cover. What do you suggest? Is this any catchment or sources or properties within a certain distance of the wind farm, or all those covered in the risk assessment? I'm just, because it doesn't tell me from looking at the condition.
I see what you mean. No, we'd be looking for any private water supplies that have the potential to be affected. Normally, we're looking out with the boundary or the drawn boundary on the maps as well, because a catchment can be within inside the boundary, but the private water supply users might be well outside the boundary. So I would expect something of this size and of this importance to do an in-depth study, not just on noise and light, etc., but also to private water supplies, especially in rural areas who do not have the uptake of mains water as an alternative. So we would be looking for the mapping of the private water supply residences, users, the private water supplies themselves, which can be multiple users on the one supply, and also the catchment areas. Now, as I stated in the inquiry, I am no hydrologist or hydrogeologist, so I cannot say for certain areas. I can only make assumptions based on my knowledge. So we'd be looking for somebody suitably qualified to do so, if that answers the question. We're looking, given that we have tables in the EIA, I've got hard copies here, so you'll see me looking down to the desk from time to time, but the EIA, we have tables which list properties and various observations about the water supplies or not on them, but we'd be looking for something more specifically. In particular, a note further down in the document that we're referring to just now, that there's consternation over whether or not it should be 40 years permission granted or in perpetuity. Now, if that were to be...
Sorry, I don't want to cut you off. I will get some of these other points. I'm just interested in mapping just now and how you...
Yeah, but I'm coming to that. This is actually a very important point. If the developments are any construction developments were to be given granted permission in perpetuity, this would be a critical factor, because private water supplies would then have the potential to be affected decades down the line. So that's why I would ask for mapping of private water supply residences, private water supply lines and supplies themselves, and the catchment areas. That's to give a background as to why I'm asking for it.
No, I understand why you're asking for it. I think I suppose what I'm interested in is if the developer looking at that condition should have an understanding of how which of the supplies you want mapped and studied. And so I'm saying, my question was just looking at the condition, it doesn't tell you that. So is it those that were in the risk assessment, or would there be some other way of expressing geographically how wide the net needs to be drawn in terms of the mapping? Sorry, Mr. Campbell, you've got your hand up.
Yeah, it does tell you. It tells you in the second line, all private water supply user properties, which I think is pretty comprehensive. If you were saying, as I understood you, that you wanted the individual supplies identified in this condition, then Ms. Lobbin's point, I think, is that all private water supply user properties should be identified on the map.
Yeah, okay, not all of them in Scotland though. So the point is, how far wide do you go?
Yeah, come in. Yeah. Well, with reference to what Mr. Campbell was saying there, the catchment areas to be identified and shown as mapped in maps, and that goes back to what I was saying. How long is a bit of string? Really, the boundaries are marked on maps which are flat, either drawings on paper or drawings online, but in reality, they could be supplying properties out with the boundaries. So we really need to look at that as a whole, as an organism, more than just, well, it's 5 kilometres from the boundary, it's 2 kilometres from the boundary, or it's within the boundary. We can't. If I were to sit down with every single one of them, that could be done, but that's not feasible in the working day, shall we say. So we ask for the catchment areas to be looked at. For example, if House A sat 3.5 kilometres away from a boundary, but the assumed catchment area for that water supply was inside the boundary with a road crossing over it and a turbine about to be built on it, would that be considered? That's what I'm looking at. That's the information I would need, or we would need here at Environmental Health to make an informed decision. And that has to be taken, each one has to be taken on its own merits.
Okay, and that's fine for the moment. It might be that the applicant or Mr. Ennis or Ms. Sidgwick wants to comment on it. I'll come back to them soon. I remember from, we discussed this in the first week, and you recall that in the risk assessment, none of these are mapped, and 4 of them I think were mapped in Mr. Robb's inquiry report, and I was asking him why they weren't all mapped the first time around, I think, and he made a couple of points. He said, well, he was concerned that some of that kind of information was personal information or might be considered that by those people who own those properties, and some of them might not want it in the public domain. And the other point was that for some, there was some degree of uncertainty about the extent of catchment or the nature of the source. The second point is maybe not one for discussion, but what about this idea about people might not want their public water supply catchment, their private water supply catchment map? Is that something you've come across previously as a concern?
Not personally, no. Maybe in other parts of the country, but I certainly can't comment on it. However, it is in the public domain. The register is in the public domain, as far as I'm aware. We certainly have private water supplies as part of our information system. We don't go into detail, for example, what the supply is and what the property is, but the risk assessments are changing and the DWQR will be changing them.
Okay, that's fine. Ms. Sidgwick, just in mapping at this point, there's other parts of this condition that I'm going to come back to, but if we can just stay on the mapping just now. If we were to require, well, I suppose if you get any comments on what you've heard anyway up to this point, but I suppose my specific question is that if we were to require such mapping in a condition, how would you suggest that that's termed so as that it would be clear which properties we're asking for? Or have you got any thoughts on that?
Yes, thank you, sir. I would refer to CD 14.2, which is the circular on planning conditions, and the need for conditions to be precise. I think in the context of any development, any applicant or developer needs to understand what it is they have to do in order to discharge a condition to allow them to move forward with construction of a project. I think the wording that we have from SAC doesn't give that precision that is needed in order for a developer to understand what is required. We've suggested what sort of information might be required in a private water supply document, and we've set out what that might be in line with the standard wording that's used by the ECU, and I would suggest that does meet the tests that are set out in the circular. The exact detail of the document is something that will be the subject for discussion if consent is forthcoming, and that document is required to be prepared, and the exact content of that document would be discussed. And if there is a need to map, for example, private water supplies, I would expect that discussion to happen in the context of the preparation of the document, in discussion with South Ayrshire Council. And that may include looking at maps and look at discussing where the relevant private water supplies may be.
But you're supposed to know that before.
So instead of struggling to set out in the condition, the terms of the condition itself, what in mapping, if required, would be that in your preferred wording, that's something which is something for discussion through the submission of the method statement and then its subsequent approval by the council.
Excuse me, sir, can I speak, please?
Yes, of course.
I did send a message. I just wanted to add something about this general data protection issue that was brought up, because I think it's quite important, and I think we need to look at the contentious industry standards. So we have Clockery wind farm, which is going on at the moment. They've done a private water supply risk assessment, which maps all the catchment areas for the that wind farm. So I'm struggling to understand why it can't be done at Arecleoch, but it can be done in other wind farms. So that was that issue. As far as the wording not being precise, I had some issues, but I don't know whether you wanted to come to that later.
I might do. I mean, some of the, yes, there are parts of that condition that I would reword, and I'm clear why I would reword it, and I'm not going to ask about it because I don't need to ask about everything. But if at the end of the discussion in this condition, if there's something which I've not picked on that you want to raise, then yeah, just come back to me and we'll do that. So, but I've got a few questions in this condition, but if we don't address your thoughts, then probably shout out rather than message me, because I'm looking at various things. I can maybe ask Alison to have an eye on messages.
Okay. I was going to say, I think for a baseline, it would be a good start just to have the water catchment areas. And as Ms. Lobban said, in particular, private water supplies need to be considered as in a holistic fashion, just as they are by the council or the drinking water quality regulator, in terms of not just the point that the water comes out of the ground, but the whole catchment area, plus any infrastructure. And one of the things that we heard about in my cross-examination was this water pipe that apparently collapsed, cutting off water to 3 properties. Now, whether or not that happened, the issue is the same one that is really important. If there are private water supply pipes that provide a supply that run within an area near a track or in an excavation, they need to be identified. So it's more than just identifying the hole in the ground where the water comes out. And I think, as I say, mapping all 35 of the private water supplies as listed would be a good start. Catchment areas, I beg your pardon.
Oh, okay, thank you. Just 2 seconds while I take some notes. Okay, I just want to talk in the next part of the condition, just the second paragraph. I'll just read it out. The applicant shall submit to the planning authority a site-specific hydrogeological report, not being a desktop study, which contains a review of the risks to all private water sources, their catchment areas, and the supplies that have the potential to be affected by the development. Isn't that, I suppose, the question for the council, and we obviously discussed this at some length in the first week, but isn't that what the PWS risk assessment already purports to provide?
Are you meaning the PWS assessment from the applicant or from the council?
I was meaning the one from the applicant in the EIA report, or it's the technical findings, I think, and I guess supplemented by Mr. Robb's inquiry report case. But I suppose what the applicant is saying is, well, we've given you all this.
Reading through the EIA report, I feel it's not full enough. I have come across several occasions where it's reporting back to desktop studies, and it was stated on the day of the inquiry that certainly I was present, there were so many days given over to site visits, which if you're doing hydrological and hydrogeological studies from desktop, that only goes so far. There's nothing beats site visits. And as I suggested, perhaps we need to look to the future, not just now, but with the future to companies meeting with local authorities and the residents prior to anything going forward, and it would prevent cases such as this happening, or be less likely to happen. I feel there really isn't enough information given. For example, Ward of Cairnlea wasn't mentioned in the original EIA. Some of the information is scarce, to be polite. I feel there's a lot been done by desktop study, which anyone can do, and I'm not saying that the qualifications don't stand, but I feel a complete review of all of the private water supplies of all the properties and all the supplies were taken into account and went out on site and looked at the actual areas and gave that back to us. It would give a fuller picture, and if necessary, doing joint visits with officers from the council.
Okay, so
to the property owners.
It would be a rerun or a better, more comprehensive version of that piece of work because you're not satisfied. It's not something you've not got. It's just that what you've got you don't think is good enough. Is that right?
That's correct.
So we're talking about this in the context of if ministers decide to give consent, and it might be the case that we haven't reached any conclusions in this, but it might be the case that we disagree with you and we think that what you've been given is good enough. And in that circumstances, would you agree that would it be appropriate then to have the condition asking for you to provide with something again that we were already satisfied with as reporters? That's why I'm trying to just get to the bottom of whether this is new information or whether it's just because you don't think the current information is good enough. And it's the second position we're in, yeah.
I'm sorry, I don't quite follow what you're asking there. I mean, no, I don't think there's enough information being in depth and good enough information being given. There is some good information in some parts, but I don't think it's full. I don't think enough has been done, and I don't think enough information has been provided, to be perfectly honest.
Yeah. Okay. No.
To go alongside the further information further down in the document where the mitigations offered and how the risk is identified and how much of a risk is identified, for example, low, medium, high, and how the conclusions are drawn and how they come to the conclusions. I don't think it matches, to be honest.
Okay,
but I didn't understand what you were asking me at the second half of your question.
Yeah, that's my fault. It probably wasn't very clear. I suppose it's probably not something we need to go back to. I was positing the scenario that if we disagree with you and think this information is correct, it would seem more natural that we would take out this requirement from the condition because it's been done already. But that's speculating on what our final conclusions are. So it's probably not fruitful to discuss it. I was going to ask you about this idea of a conceptual site model.
Well, so, before you come on to that, Ms. Little, if you were to take that condition out, for example, if you did disagree with us and you were to take that condition out, would that then leave you with the complete and full information on all of the private water supplies, all of the catchment areas, and all of the properties who take private water supply. Would that then leave you as the reporter with full required information to make an informed decision? That's how I would look at that question then.
Yeah, well, indeed, and that's something we're going to have to reflect on. I want to move on to this idea of the conceptual site model. And so, you might remember when I was asking Mr. Robb about this in the first week of the inquiry, I think what I had been, when I saw that phrase, I think I was expecting to see a model, that kind of model shown in some sort of graphical format, whether it be mapping or sections or that kind of thing. But I think Mr. Robb said that his conceptual model was really to be found within the body of the risk assessment. There's written descriptions and explanations and so on. So I just wondered, what's your expectation here for a conceptual site model? Is it something more than that written description?
Yes, it would be that. I understand where Mr. Robb's coming from. Don't get me wrong. I don't think he's wrong in saying what he's said, but I would be looking for better graphics, better explanations other than the wording, which would include mapping of the private water supplies, the sources, the catchments, and the properties. And that in relation to, and that would be X, Y, and Z.
Okay, that's fine. I'm going to move on to leachate generation from border pits and that issue. But I wonder, I'm just going to give the applicant a chance. Is there anything?
Sorry, what number are we on now?
Sorry, what was that?
What number are we on to now in the response document?
Right. Well, I'm still on 36, condition 36, but I'm about to move on to condition 14. But before I do that, I just want to ask: is the applicant anything to add just in terms of the latest exchange?
Yes, calling on behalf of the applicant. Very briefly, our position is that this application was properly scoped. We were given, that's the proper time for the councils to give the information to the applicant to consider. They then went off and did their own assessment, which is duly reported in the environmental impact assessment report. Within that, chapter 10 does set out the relevant catchments, and all that Mr. Robb has done in relation to his inquiry statement is to give more detailed refinements of those catchments that had already been identified. And the fundamental issue here is we're identifying the properties to be effectively monitored through the condition. And we're satisfied that the evidence that we have provided is robust and covers these matters. And quite frankly, it doesn't matter if we haven't got one other property that shares the same source or tank. If we've identified where the water supply is, that is good enough. That's just extra detail insofar as these matters are concerned. And I don't really want to go over the evidence that's already been given. But our view is all this material has been provided to you. And in essence, our position, of course, is that the condition, therefore, as put forward by the ECU, is the appropriate one to proceed on. Because what it really is identifying is providing appropriate measures to monitor and mitigate, as opposed to what effectively SAC seem to prefer to go back to trying to do some sort of further reassessment. This is, in essence, the heart of the difference between those two conditions. And the difficulty with it is the wording always ends up really not in a condition format with precision. and we obviously don't accept some of the subsequent stuff that we'll come to talk to. That in general terms sets out our position relative to that particular matter, sir. Thank you.
May I come in before we leave this topic?
Sorry, David, you're on mute.
Okay, thank you. Dr. Connor, I'll come back to you in a minute. Thank you, Mr. Innes. I understand that's the applicant's position here. I do want to do a bit of explanation of the council's condition, though, just because we need to reflect on which one we prefer, and if we were minded to use the council's condition or something like it, then I just need to explore the implications of that, in particular, what that means for the kind of suggestions that Dr. Connor's made for this condition and for others. So I'm going to spend a bit of time looking at this material. I understand your underlying position in relation to it. Dr. Connor, what I was about to do was to go on to leachate, but do that in condition 14. So, but I was going to come back to condition 36 again later. Are you happy just to let me go on, or did you have a particular point about what we've just been discussing?
Yeah, I just wanted to come back on Mr. Innes's point, which was that he said it doesn't matter if more private water supplies are identified on the same supply, because it's the same supply. I'm afraid I disagree with that, because it goes back to the problem of demand. If you don't know what the demand is on a single private water source, then you can never know whether in fact your construction work is actually affecting that demand. So I think it's actually disingenuous and unfair on whoever happens not to be identified within that supply. It does matter who is on that particular supply, and it goes back again to whether there is damaged infrastructure. So the whole point of a private water supply risk assessment goes back to not just being what comes out of the ground, but the whole supply system, as well as the water that comes out of the ground.
Okay, yeah, I understand that point. Okay, can we just talk about leachate generation from borrow pits? So, because it's mentioned here in 36, but it's also mentioned or arises as an issue for discussion in condition 14. So, can we look at condition 14 for a moment, and then we'll jump back to 36. So, condition 14, if people have it there, this one happens to be agreed between the council and the appellant. Ms. Law, 36 talks about studying, or has your version of 36 as a requirement to consider leachate from borrow pits. But I just wondered whether wouldn't that already be caught by condition 14 here?
In the borrow pits, in this condition here, it seems to be dealing with, and from what I can make out, it seems to be dealing with legislation that SEPA deal with as to water on land and ground other than a private water supply. I'm looking at specifically private water supplies and their catchments. Now, it may cross over into the SEPA legislation, but we, just because it's mentioned the mitigation and leachates and the scheme of works in relation to borrow pits does not necessarily mean it will be put before us with regard to private water supplies and environmental health. So I would be looking for that specifically in relation to water and catchment areas which have the potential to feed to private water supplies and to private water supply users. For example, Arnameen was given as a pretty good example. Burnside is a pretty good example because they're very, very close in to areas, Arnameen being close to the road, but Burnside possibly being closer to the borrow pits in the past. I mean, but borrow pits in specific to boreholes as well, to bore wells, because nobody really knows where the water's coming from underground. You'd go for miles, it might be directly in below.
So, I mean, to a certain extent, this might not matter one way or the other as long as it's dealt with somewhere, in your view. But I'd wondered, for example, if 14 deals with borrow pits and there's a concern about the effects of borrow pits on private water supplies, whether so the CC there, which is so there's to be the purpose of the condition is for a scheme for the working and restoration of each borrow pit, and part of that is that requirement C is that the scheme includes drainage, including measures to prevent surrounding areas of peatland, water-dependent sensitive habitats, and groundwater-dependent terrestrial ecosystems from drying out. And I just wondered, might that also instead include measures to protect private water supplies, and then you would that condition would allow PWS to be properly considered through condition 14, at least in terms of the effects from borrow pits. I just wondered whether that was another option for that condition.
It's possible it could be put in there, the drainage to prevent the areas of drying out and the leachate going, but we'd be looking for robust measures to make sure that nothing was going to potentially disturb or contaminate the private water supplies. I don't really know where it would go in there if you were talking just on C itself. It's not really just to do with the drainage, it's not just drainage we're talking. That I'm talking about when I talk about leachates. It's not just, perhaps maybe leachates isn't just the only word I would use, but the potential for blasted rock to release things such as non-soluble aluminium, for example, into the water, which you could never get rid of. That would destroy a water system, a water supply. It wouldn't just destroy a private water supply, it would destroy a water system, but it would knock a private water supply out for good. That sort of potential's there. We would actually prefer if they used quarries, local quarries, and put the business into the local community. That would be a better. You're on mute.
Sorry, David, we can't hear you. David. Sorry, we didn't hear that. You were on mute.
On mute.
Sorry. Yeah, I want us to try and just stick to the terms of the conditions instead of straying beyond that. So when I ask a question for everyone, if we can try and restrict our answers just to the questions I'm asking, it'll go quicker. So I suppose for the applicant, I mean, these questions are speculative, but so this was an option that occurred. This seemed to be an option, would be to use 14 to deal with any concerns about the effects from borrow pits on private water supplies in terms of the scheme for working with borrow pits. Does the applicant have any response to what we've just been discussing?
Thank you. I mean, I think that between condition 14 on borrow pits and 36 on private water supplies, as they are currently drafted, which is adequate to protect the issue. I don't think any more is required.
Okay, that's fine.
May I come in?
May I
Mr. Little?
speak?
Yeah, so yes, both Ms. Lobban and Dr. Connor, yes, can you, Ms. Lobban, why don't you go first and then I'll ask Dr. Connor.
In response to the applicant statement there, it goes so far. I would say the putting in of conditions such as 14 and 36 go so far. However, it depends. It's another critical factor there is the topography and terrain. For example, if the borrow pit is up gradient, and we're looking at conditions that are put on for all wind farms, not just this particular wind farm, but topography and terrain has a lot to sway this as well. For example, depending on the private water supply, because the area that we're looking at is a very large area in this instance. So it may be adequate for one, but it might not be adequate for another. And how do we know that?
Okay, Dr. Connor.
Thank you. We heard in answer to your question to Mr. Robb the drainage, and he described the borrow pits as having gravel and most of the water running downhill towards the valleys, but a proportion of that going vertically downwards into the fissures and then supplying the borrow pits. So I think, you know, he did provide in oral evidence a conceptual site model of the drainage, which I think is what is of great concern. We also had discussion about refueling in the borrow pits. So I think there are measures that could be taken to reduce the risk so that, for example, no chemicals or refueling actually occurred in the borrow pits themselves. I don't know how you get around the problem of blasting because, as Ms. Lobban said, the blasting itself tends to actually force rock particles, for want of a better word, down towards the fissures as well as out sideways, and that in itself will tend to affect the way that water is able to actually travel in the fissures. I don't know how you get around that, and I don't think it would be reasonable to have a condition for that.
Okay, thank you. I mean, just to explain, as I understand it, that there are two schools of thought, if you like, here. There's all this detail, and I don't think there is much disagreement that all of this is relevant material. It's simply that the applicant's condition 36 just says we'll submit a scheme for the protection of private water supplies. The council will hopefully agree that, or ultimately they'll agree what that is, and then they'll do it. And it just defers a lot of this detail, whereas the council's proposed conditions and the suggestions that you would also add in, Dr. Connor, provide more material, more meat in the bones in terms of the conditions themselves. So that's the discussion I'm interested in having. Not, I'll come to you in 2 seconds, Mr. Innes. Not so much the scientific arguments here. It's about how best to frame the conditions to then ensure all these things get properly looked at, and that's how I want to. That's the debate I want to have this afternoon, Mr. Innes.
Yes, thank you, Sir Collins, on behalf of the applicant. Just to say, in terms of that regulation of the activities, which we might call the source of any potential issue, our position is they're best put in the respective parts of the relevant conditions that are effectively dealing with those source matters, whether it's the borrow pit condition at 14 or the SEMP at, which is the Construction Environmental Management Plan at 18. These effectively provide the codified ways in which those particular activities are controlled, and the detail is put in as part of those particular aspects, and then the monitoring and enforcement, etc., is focused on those core, what one might call source conditions, which are effectively regulating the construction, etc. Our approach, obviously, to condition 36 is really focusing entirely on the private water supplies, looking at how those are essentially going to be monitored and protected insofar as that condition is concerned. But the difficulty with mixing and matching is you're putting in a bit to the private water supply that's about source. And in my submission, what that does is it just confuses the picture. And I think the key issue here is focusing in on, there's a control in relation to the borrow pits, there's a control over the construction activities, including things like a pollution prevention plan, which deals with all these matters such as where you can and where you can't refuel vehicles, etc. And it's dealt with comprehensively, and the rules are clear. And the difficulty is, as soon as you start diluting it elsewhere, it loses that clarity and purpose, which is why they're there. They're supposed to be essentially a code that deals with the borrow pit. It's all contained in one document. There's a code for the overall construction, which is managed comprehensively. And then it's actually much more straightforward. And I think one of the problems is if you start diluting those control conditions by putting them elsewhere, it's not really that effective. So in our submission, the applicant's position is, and I don't want to keep coming back to it, is those source controls are where a lot of these matters are. And that is where they properly should be considered and controlled. And trying to bring in bits into other conditions is simply not necessary in terms of the circular, and also adds to the potential of discharging the same matter twice in a slightly different way, again, which is not something which should be happen. So setting out that general framework, I'm not going to keep coming back if people are going to start talking about source, but I think that was just helpful to set out how we envisage these set of controls operating. And so 36 is very much just targeted at private water supplies and the mechanisms around monitoring them. And effectively, if you're looking at source control, those are in those key upfront conditions that actually manage the process. And that is essentially a tried and tested condition process, is to have those codified in a single place. So you've got to essentially, to the contractor, they get the borrow pit plan. Here's what you have to do to comply when you're doing borrow pits. And I'm sorry, but that keeps it straightforward, it keeps it simple, and it makes it clear as to what can and can't be done. And I think it's an important part of conditions that this precision and clarity is very important in terms of discharge and being then able to ensure that they're properly complied with. I don't really have anything to add, because I'm not going to keep coming back to that point, but it's trying to make it clear that those distinctions and why they're there and why they're workable at a practical level.
Let me just make sure I understand you, Mr. Ennis. And so there's inevitably overlap, and it's hard to avoid overlap between conditions, and it's beneficial to avoid it as much as you can. So let's just say we're talking about the council's version of 36 and this 14 here, and let's say we as reporters feel that it needs to be explicitly brought out that works on borrow pits have to consider the effects on private water supplies. I'm just positing that, right, as a hypothetical. You're saying deal with that in 14, don't deal with it in 36. Is that right?
Simply, yes, it should be dealt with in the proper condition that's dealing with that particular facet. And the difficulty with the SAC is effectively this condition lacks the clarity and focus as to exactly what's to be achieved. And simply put, throwing in bits about things that might or might not be of interest to a future thing, is a future discharge, is not really that helpful. It should be short, specific, and tell you what you want to do. And this is like a topic list of things that might be of interest. And of course, we've led our evidence in relation to the borrow pits and the underlying rock structure and the likely potential for any leachate not happening because of the particular characteristics of that. So as I say, that's a general point, and I don't think this condition is improved by adding bits and pieces of things that might potentially be of interest to the council in this particular discharge. It's not because that if the council have got an interest in discharging the conditions, it's for them to organise who they involve in the particular discharge of particular conditions. But if there are aspects, this shouldn't be a condition just because it's convenient to say, I've got all these issues that I'm interested in, and I want them to be potentially considered here, when there are other conditions elsewhere which clearly articulate and deal with the particular position. So for example, on pollution, there's a clear provision of the SEMP, which requires a plan to deal with it. And again, talking of construction sites, what you need is a clear and unambiguous plan that is easy to straightforward to implement and is clear and covers the whole site. So all the potential risks of pollution will be encompassed with that plan, and they'll be fully dealt with, and there'll be a decision reached and it's approved. And I don't think then saying, well, I want a bit of a pollution condition that deals with private water supplies differently is going to help. I think it just confuses matters and results in essentially a position that is not helpful.
Okay, just one question, final question on that. Is that an argument for not having a private water supply condition at all, but just having private water supplies as a receptor or sensitivity in each of these other things? Because inevitably we have it by mentioning them in 14, but also having 36. Isn't that providing overlapping?
No, the fundamental point about 36 is ensuring that the right properties are identified and thereafter monitored to ensure that if anything were to go wrong, that it's identified and that action can be taken. The primary purpose of 36 is a mitigation condition and a protection. That's the way it's worded in the ECU phraseology. Is it's actually relatively straightforward. It's very focused. It's dealing with a very specific issue and a very specific receptor. And that is a receptor-orientated condition to make sure that there's a plan in place to specifically deal with those receptors and it's actively managed. And I think that is correct. That's the right way to treat a private water supply. It should be a coherent plan. And really, if it's issues about pollution and everything else, they're dealt with elsewhere. That is right too, because effectively that is part of the management of the overall construction process. And if I may say, that is where the primary focus of the condition goes, which is to ensure that at source there is, throughout the construction, that it's properly managed and that effective measures are put in place to ensure that it's delivered in the way that's set out within those plans that are approved.
Okay, let's go back to 36 again, because we haven't finished going through the council's version of that, and I do still have some questions on it. I'm going to
Can I come in there, please, Mr. Little? In all due respect to the applicant, I feel that they're trying to narrow all the comments on private water supplies down to one section, which I feel it would be incorrect. And pollution would be dealt with elsewhere within the document by other mitigation factors, and I feel that's incorrect as well. Don't forget, at the end of the day, we are talking about human life and the potential for humans to become ill or worse through contaminated water, or the alternative is possibility of the water supply being stopped altogether. So it's a really deeply serious issue that needs contemplation throughout the document, not just in one section. If the water supply were interrupted, disrupted, or completely stopped altogether, then we're looking at different legislation. It's not just private water supply legislation. We are then looking at housing legislation, and we're also looking at loss of income and loss of property to businesses and to owners of properties. So I understand what Ms. Dennis was saying, try and get it focused. However, I totally disagree that it should only be within one section within the conditions. I feel that private water supplies are such an important, such a critically important section that it has to be cross-referenced throughout the documents. And pollution is not just dealt with under pollution and other guidelines and other legislation. Pollution has the potential to affect across many different types of legislations and in many different ways.
Okay, thank you. Let's just go back to 36, if we can. So,
David, I think Ms. Spence would like to speak.
Ms. Spence, on you go.
You're
Spence.
muted, Ms. Spence. You're muted. Your microphone is muted, Ms. Spence.
Sorry, the click didn't work. I think that there should it here. What if the somebody's private water supply were not reinstatable if things were pear-shaped, and what the responsibilities of the applicant should be in putting these people in a situation where they have a house which has a proper water supply, and if their property is rendered uninhabitable by the actions of the applicant, then measures to reinstate and put those people in a proper situation that they were in to start with. I don't think that's an unreasonable request, given the seriousness to people's life and livelihood, and you know, the situation where they owned a house and suddenly they own a house that's livable. I think something should be considered as a last resource.
Can I come in there, Mr. Little?
Yeah, is it? I'm keen to move on.
It's to do with a habit. It's to do with Miss Spence's statement there. It's just to follow on. It won't be long.
Okay.
With regard to what Miss Spence was saying there, as a last resort, there shouldn't be a last resort. That's why we're in the position we're in just now, and that's why conditions are put on. The conditions should be sufficient that, well, certainly the risk assessment should be sufficient that we should be able to, everybody should be able to look at them and see clearly exactly what is at risk and what isn't at risk, and negligible shouldn't just be put in because they think it's thought that things are not at risk. To reinstate a supply back to its original way or to make the house habitable again, that might not happen. That might not happen. It might not be possible. It's simple. That's why we need the conditions. We need the risk assessments, and we need the map in the way it is. Yeah. So we're able to make that informed decision.
Ms. Lowen, I think we're in danger of coming back over the same ground, not least from this morning, but also from the other week. I understand your position. I want to talk about, I want to go back to 36. Now, we've dealt with borrow pits, or talked about borrow pits. The next part of that, which is the last sentence in the second paragraph, is about mitigation measures. And so that's not both versions of the condition requires mitigation measures to be agreed. So that's fine. The final the final paragraph of the council's version of the condition talks about an emergency action plan.
Yeah.
So I understand the purpose of that. I suppose it's the same thing that could be required through the applicant's condition as well, couldn't it? It's just that it's not made explicit in their version. Would that be your understanding, Ms. Aubin, that when the applicant, under the applicant's version of the condition, when they come to you for the method statement, that you could include an emergency action plan through that, or don't you think that would be possible?
I'm not really sure, as long as an emergency action plan is there, because that is a critical inclusion. For example, going back to what Ms. Spence was saying about problems occurring, should serious problems occur, the ecological work officer of works will be able to notify companies, etc. But we also need an emergency action plan. What happens? Who's contactable by all sides, by the private water users and owners, as well as the developers. It's not just the developers who are in this inclusion here. And that's why I've put it into the private water supplies, because I don't see that inclusion anywhere else. And the 24-hour, 7-day-a-week contact number, I don't see that anywhere either. So that's why I've put that in. It's a safeguard on all sides, not just one side. We're not just talking about applicants and users and owners here. We're talking about everybody should have the ability to contact.
Okay, that's fine. Dr. Connor, I see your hand up. I was going to come in and ask you at this point anyway. So I wanted to move on to your two suggestions for 36. But just so before I do that, as I understand it, you're supportive of the council suggested condition here, and when you provide two suggested exceptions, it would be into the council's condition that you would. That's what you're asking for. Is that right?
I think so. I agree with the wording in the middle where it says work shall not commence on site prior to the written approval of the planning authority to such a report being obtained. And the reason for saying that is because of our experience with Snedden Wind Farm. There should not be a conception from the developer that simply submitting a report is adequate. It has to be that report is agreed by the council, and I think that wording is really important. Otherwise, you'll end up with another enforcement appeal. So just submitting documents is not adequate. They have to actually be signed off and agreed. So that was just to make that point. Just going back to the disaster management, which is obviously a requirement of the EIA regulations, that it's before you decide the consent. We did speak about this, and at the moment, basically, disaster management is bottles of water, but you can't provide any kind of disaster management if you don't know what the demand is from each individual private water supply property and the supply in general. It's going round in a circle a bit, but it goes back to needing more information. And I think the other thing that has come out of my experience is very much that private water supply owners need to be consulted, and consultation is not a one-way process. There has to be signed off agreement from private water supply owners that they have been consulted and that they do agree with whatever is proposed. It's not that the developer should be able to go along and tick a box and say, we've spoken to somebody, because that's actually not always what happens on the ground. So I think there has to be agreement in terms of, is this a Bowser that is going to be delivered and provide a week's supply before something else gets sorted out? If it's a long-term supply, what is it that would be acceptable to that particular individual household? How is it going to work for each household? That's the issue.
I think you're on mute, David.
Thank you. So thank you for that. Just looking at your two additions, the first one I think I understand clear enough. What you're saying that is if you're going to be mapping the private water supplies, then it would just be, I assume the purpose for what you're asking is that it would just, for the reader, it would be clearer so that you can look at that material with also with the wind farm map as well. So it's just for reference purposes. So I think that seems to be straightforward in as much as I understand that point. So I don't think we need to necessarily, I don't think I need to ask you any more about that.
Can I just add one last thing in there? When you're talking about the mapping there, the mapping exercise, if you pull everything that's just been talked about there together, the private water supply owners and the long term, should something happen, we, Environmental Health and the DWQR, do not consider Bowsers to be a suitable alternative potable water supply, full stop, end of. So a Bowser may provide water in emergency for a week or two, but if there's no potential to go on to mains, as in many rural private water supplies throughout the country, not just here, if there's no potential to take up mains water, what is the alternative? And that is the crux of why Environmental Health, myself and colleagues at Environmental Health started looking seriously at the private water supplies and the conditions and development, not just wind farms, but construction and development, because if something goes wrong, it's disastrous.
Okay.
Are we going to come on to monitoring? I'm sorry.
Yeah, I'm going there right now. So because that's your second suggested insertion. So if we look at that, I don't want to discuss the Water Framework Directive and the DWQR because we talked about that in the first week. So I just want to talk about the mechanics, if you like, and the practicalities of what you're wanting. And I just want to understand how it might work. So this asks for 6 months pre-construction monitoring of every PWS prior to construction, and monitoring would extend to 3 months after final commissioning, or until baseline values for each PWS are established. I wasn't really clear what you meant by that. Can you explain?
Yes, well, I think Mr. Robb also alluded to it. You have to know how individual private water supplies will vary in terms of both supply and water quality, excuse me, throughout the year. And he felt that 12 months was excessive, although that's what's suggested by SEPA for at-risk groundwater dependent ecosystems. But clearly people get less. But he felt that if you had 6 months, it would be enough to monitor seasonal change. So you need a proper baseline to start with. Then you obviously need proper monitoring, which has to be under the regulations at the point of consumption. It may also be the raw water source itself, but it has to be at the point of consumption. So there has to be a dialogue with private water supply owners. As far as monitoring afterwards, in fact, what came out in oral evidence was that because the British Geological Survey consider that groundwater flow is actually quite slow, maybe for years, and we had some evidence from Miss Lobban about Wood Park, which had, I think it was Wood Park, that recorded problems some while after the original Arecleoch and Kilgalleoch wind farms. I think there is a need, in fact, to continue the monitoring for longer than 3 months if it is a groundwater dependent supply, particularly a borehole, perhaps not so much for the more superficial groundwater supplies that are shallow wells and springs, or shallow wells, I should say, but certainly for borehole supplies and possibly springs as well, given the conceptual site model that Mr. Robb presented at the inquiry. So I think it needs to be a bit longer. Okay,
so I'm just thinking about, I appreciate this isn't your area of expertise, and I'm just thinking of this as a planning condition. So you're in the post-construction monitoring period. You've monitored the borehole or the well or whatever it is for 3 months. And what the condition says, you do it for 3 months or until baseline values for each PWS are established. How do you know at the end of the 3 months whether or not you've established a baseline?
Well, you hopefully have got your 6 or 12 month pre-construction baseline monitoring to go to. So that provides your reference level. And you use that as your reference point.
So if it's back to what it was before construction, then that's back to baseline. Is that the kind of idea that we're talking about?
Yes.
Right, okay, understood. Okay, bear with me. I'm just gonna work out what because we've covered some of this ground. So I'm just going to work out where I want to go next. Okay, I suppose I just want to get back to Mr. Innes or Ms. Cedric. You've heard all those exchanges, and again, I kind of understand the applicant's position as you suggested, but I just wondered whether you had any comments on Dr. Connor's suggestion here for putting the monitoring in here explicitly rather than dealing with that through the terms of the condition. Do your version of condition 36.
I think the monitoring could be referred to in the condition. I think my understanding is that the requirement to monitor doesn't relate to the point of consumption, as in where it comes out of the water comes out of a tap, but it's the tank or the well or whatever and things, and that's the point at which you would monitor.
I'm afraid with respect, that's not correct.
And secondly, comments about the applicant, the second thing that's important to understand is that the applicant does not have the right to go into other people's private water supplies. So the issue is it's an offer to monitor, and provided permission is given, the monitoring can take place. And that's pretty important, but that the condition can't be written in a way where there is a requirement. The scheme will be provided, and obviously within that scheme, that will have to seek agreement with those who have control of the tank for monitoring to potentially occur at source or even at any property. We don't have the right to go into people's properties and demand to test their tap. It has to be done on a voluntary basis. So if parties do not accept monitoring, the applicant's not in a position to force that, although we do know that other parties do have powers of enforcement and mandatory monitoring, but it's not the applicant. So I just want to make it clear that any scheme is on the basis that parties agree for the tank to be monitored. And if not, then there may be agreement to monitor elsewhere, but part of the process is agreeing the monitoring, and that will be part of the scheme that's submitted. And as I say, parties may or may not participate. And that's an important component part of the private water supply monitoring. Now, our experience has generally been that parties have wanted it monitored and do so, but equally it's got to be very clear that it's on that basis that parties have to agree to that monitoring being taken place, and that's part of the submission of the scheme. And equally, if there's any debate about sources or where it's to be, again, that's a matter for the scheme to be approved. If the council have a different view and parties want them tested at the tap, then that can potentially be part of it. The difficulty often with testing at the tap is it's already been through all the treatments, and therefore there may be elements that are missed. And generally speaking, that's why most water monitoring is undertaken before the treatment. Or any other elements of treatment. And for example, if somebody has a borehole, they'll often have other measures that go alongside that to treat that water by the time it gets to tap. So often they will often test at the borehole because that's where they want to make sure that there's various things happening. So as I say, I think that's why it's a scheme to be submitted, because that scheme will go through the process of the potentially affected properties, which have to be agreed. And similarly, what monitoring is proposed is all part of that scheme to be submitted in that scheme 36. But I didn't want, Dr. Conrad said all sorts of things have to be agreed with, that certain schemes, etc., would have to be agreed by third parties. The discharge of the condition is discharged by the planning authority. We will set out in the extent to which we have agreement to monitor or not, but you can't have a system whereby a third party essentially blocks the ability to comply with a provision or a condition. That wouldn't be lawful in my submission. So those are just general points about those monitoring schemes. And I think it's important to understand that, because I was worried that we were getting to potentially drafting that might say you have to monitor. We can only monitor with agreement.
But that's fine. Mr. Campbell was going to say something, so I'll come back to him in a minute, I think. Well, what's your name, Mr. Innes? Can I ask you about another one of another aspect of Dr. Connor's suggestion, and it would apply whether or not we defer all this to the agreement of the scheme, or whether or not one's tempted to put more of this in the conditions themselves. But I'm just interested in the point her suggestion was that in the provision of the results of monitoring, rather than it being sold to the council, in Dr. Connor's version, that that information would also be supplied to the PWS owners, or perhaps occupiers might be better, I don't know. But does the applicant have any thoughts on that as a suggestion?
There's always difficulties with an applicant being forced to give things to third parties. Clearly, again, having a requirement to do so can be quite difficult because the ownership may change, the occupation may change. Normally what would happen is if the information is provided to the relevant planning authority, and there are duties within the conditions for all these matters to be properly forwarded to the relevant planning authority. In my submission, it's probably more appropriate for them to have that direct contact. We will have a contact at a certain level over an agreement, and it may be agreed outside the context of the condition that the private water supply monitoring is given to that party, but it's forcing that third party process can be difficult. And equally, if you start saying they've got to have been notified, well, how, what provision would be for notification? Do we have to have recorded delivery letters, etc.? I have no problem with suggesting that formally should sit with the council, but often in relation to relationships with other parties, things are arranged through other means. But I think it should be with the council, who will hold all of that information, who are a public body, who should have that potential requirement if required.
Okay, thank you,
Yeah, Dr. Connor's keen to come in as well.
Yeah, I'll come back to you, Dr. Connor. I'm going to go to Mr. Campbell first, and then I'll come back to you, Dr. Connor, if that's okay. Because there's two things, Mr. Campbell. You were going to say something else earlier on, which I think was about whether monitoring was at source or at tap.
Yes, I was.
And the other thing was, I was just going to ask you if you have a view on what Mr. Innes has just said there, or whether one of your council colleagues has a view about this idea of it's simpler keeping the condition is simpler, having the requirement to report to the council.
It's obviously simpler to report to the council, but simplicity may not be the determinant. The determinant may be the people who are affected or might be affected by the development. I don't want to intervene any more than I have to. My previous point was made for me by Mr. Innes, and I don't want to repeat it. So we're looking for simplicity here, but there's nothing complicated about intimating to the owners of private water supplies when issues arise.
Okay, thank you. Dr. Connor, then, you want to come in?
Yes, can I just add that actually, having been on the other end of both types of conditions, one that didn't work and one that did work, that the one that didn't work was the one that unfortunately the applicant is suggesting, which is where the results go to the council, and consumers are, if something happens, they are totally unaware that their water supply is very badly affected and become ill. So that's a scenario where it doesn't work. I've also been on the other end of planning conditions where there has been a requirement for private water supply consumers to be copied into the monitoring results within 24 hours or so of them being sent to the applicant. It's done by email and it's not difficult. It does mean that private water supply owners at least have immediate notification of results, as well as the council. And I think if you're drinking the water, you have a right to know what's in it. And as far as the monitoring goes, I accept that you can't force people to have the water tested at their kitchen tap, but I'm sure Ms. Lobban will confirm that that's actually what the regulations say. And certainly for one of the other wind farms next to us, that was the requirement. So I don't think there's anything difficult about it. I think most private water supply owners will agree to having their water monitored as much as they can. Obviously they have work and so on, but as much as possible, most people would agree to having their water tested.
Okay, thank you, Dr. Connor. And just, I was making notes there, so I just want to make sure I got it right. That example you gave of where it worked in your view, it was the planning condition which required the monitoring to be shared with the residents as well as the council. Is that right?
Yes, that's correct.
Okay. Right, it's 3 o'clock. It might be a good time to take a break. I can just also look at my notes and see what stuff we've already covered and I don't need to go back to. So if that suits everyone, can I suggest we have a break and come back at 3:10? Is that okay? So if you just turn your video and your sound off and just switch on again at 3:10. Thank you very much.
On a formal break.
Hi there, Ms. Spence. Yes, we're having a break until 3:10.
Thank you. Thing knocked off.
Okay, everyone, I hope you've had a chance to have a short break. I think I want to move on from 36, but we're still in the area of private water supplies, because Dr. Connor, a few of her suggestions in relation to private water supplies with her other conditions, and I bear in mind what Mr. Ennis said earlier about avoiding duplication or confusion as to where a particular issue needs to be discharged. But I just want to explore Dr. Connor's suggestions a bit. We're not going as fast as I'd hoped we would, so can I make a plea that we don't go over a lot of the same evidence that I've already heard several times now. I understand parties' positions about the importance of these issues. I just want to focus on how they can or should be controlled through the planning conditions in the most effective and appropriate way. So can we look so in response to Dr. Connor's suggestions about actually, bear with me 2 seconds, I think I've lost my train here. Yeah, I want to look at, can we look at 27? Because this may seem a narrow point, but one of the reasons we need to think about is if something has to be included in a condition, where it best goes. And I think in responding to Dr. Connor's proposal in terms of monitoring, the applicant pointed to 27, which is the water quality monitoring plan. And again, this defers details, if you like, of these arrangements to be agreed between or submitted by the applicant and agreed by the council. And the council's content with the particular wording of this condition. So I suppose my question is for the council, whether it's for you, Ms. Logan, or someone else. Do you see the scope of that condition extending to the monitoring of private water supplies?
Yes, I do. We've successfully implemented that in previous applications from different companies, and it was done in conjunction with sampling for SEPA, and the results were gathered weekly and then sent on a monthly basis through to South Ayrshire Council and SEPA together, and we then were in a position to then provide the information down to the householders. However,
I was happy with your answer up to that's a fair answer for me.
But however, that is the success of that is totally dependent on the residents getting information through from the council. So it's something although it's a generic condition, I think really it has to be looked at individually for each individual application of construction, not just for wind farms. But again, it's dependent on whether or not householders have the water monitored at the point of use. And to say that filters would alter the water that's coming through, that's the whole point of doing water monitoring at point of use.
Ms. Loban, your first word and answer was yes. That would have been fine for me. I just wanted to know what the answer was. So that's fine. Let me just bear with me, and I just want to see where I was going to go next. Okay, can I just ask about 15 then, which was another condition on which Dr. Connor had a suggestion. This is blasting at borrowing pits, and what 15 requires is a monitoring scheme for border pit blasting to be submitted to and agreed with the planning authority. So I'd assumed that was about vibration, if you like. The purpose of that, and this might not be a question for you, Ms. Lawin, I assume the purpose of that condition is about controlling vibration and noise rather than with regard to water supplies. Is that, am I right, Council?
Well, I would certainly agree with that, and that brings me back to why we need the conditions for private water supplies throughout. We discussed earlier about blasting and potential contamination.
Right, okay, that's fine. Bear with me just to navigate where I'm going.
David, Dr. Connor wants to come in.
Sorry, Dr. Connor, I was going to go on to a bit about decommissioning, but if you've got a comment to make, then that's fine. On go while I find what I'm looking for.
I just wanted to be very brief because I know you want to move on. It's just to say that in the water quality monitoring plan, which has obviously been based on Marine Scotland rather than private water supplies, whether it's possible to put in the planning condition that there should be groundwater monitoring within each of the hydrogeological catchments, which Mr. Rob has described as following the surface water catchments. So it would basically be one for the Tig, one for the Crosswater, one for the Dusk and the Cree, because those all actually have construction elements or borrow pits in them, but it would cover them all.
Okay, that was the Duist, the Tig and the Cree, did you say, yeah?
And the Crosswater, David.
Sorry, I'm talking to myself here. There's 4 surface water catchments which follow the hydrogeological units.
I've got a note of those. Thank you, Dr. Connor.
Okay, thank you. I said I wanted to talk about decommissioning, but what I meant was the construction environment management plan. So can we have a look at condition 18 now, which is another one which Dr. Connor made suggestions on. And just looking ahead, we'll go into 11 and 4. And I think, Dr. Connor and Ms. Crawford, I think maybe those are the only ones that would take us to the end of your comments, I think. And so it just seemed that you might have made a comment on my site, I'm not sure, but that would have, it means we'd have been able to deal with all of your comments in one go, right? And then you could relax about it, stay on the call or come out of the call, whichever you please. But if we just look at 18 and Dr. Connor's suggestions for 18, construction environmental management plan. So this is a condition which the council and the applicant are agreed on. So what I just wanted to go through is Dr. Connor's additional suggestions and the applicant's response to those. I don't think it will take a lot of time, but I just want to make sure I've ticked them all off. So, and I'll give you a chance, Dr. Connor, if you want to come back in at the end of this. But just so as I'm understanding what the applicant is saying. So the first of those that Dr. Connor had suggested was about water abstraction. So, and the response, by the way, Mr. Innes on the Sidgwick, if I misunderstanding, if I'm putting the wrong words in your mouth, then just tell me, and we'll stop, and you can put me right. But water abstraction, the response from the applicant is, well, that's a controlled activity under the car, and nothing here in this consent would allow any water abstraction. So it would be for a subsequent consent. Septic tank drainage, likewise, that's controlled under car, and nothing in this permission would allow drainage from any septic tank. At least that's how I'm understanding the applicant's response. Refueling, the applicant's expectations is that this would be covered in the pollution prevention plan under point F of that, and that would be normal practice in my experience. Likewise, that HGV routes and deliveries would be covered. Track excavation depths, I think the applicant's response was, let me find that this would be covered in the water management plan. So fine, I understand that response. Disaster management, the applicant's understanding is that would be covered in condition 18, which is flooding, and point I deals with the water management plan, and 14 for borrow pits, which is that's the borrow pit scheme of works. So that disaster management, if you like, would be covered in the schemes to be submitted through condition 18 and condition 14. The final one was monitoring. I think we've discussed that already, so we don't need to go back into that. So I think I understand people's positions well enough on that condition 18. If the council's got any thoughts on that exchange, give me. But you already agreed that condition. Dr. Connor, that's as I understand the applicant's position in response to what you'd said in your suggestion. If you get anything further you want to add before we move on to 11?
The only thing I was going to say is that many of these measures really need to be, I think they should really be before you actually decide the consent. I'm still not clear what a lot of these measures actually are, and whether they're likely to be effective. But I understand that the KEMP as submitted is basically a generic document with no specifics in it, and the mitigation is likewise outlined in chapter 10, but is sort of general mitigation measures. So, I'm not clear what the mitigation measures are that are specific to individual water catchment areas. That would be my only comment. The KEMP doesn't seem to actually address it as it stands.
Okay, that's noted. Sorry, Ms. Sidgwick.
Can I just briefly come in? There is an outlined SEMP, as Dr. Connor has identified. It's anticipated that document would be significantly developed based on the site-specific issues and things, and it would include all of the matters that are raised in the draft condition. It's entirely normal practice to do this. SEMPs do need to be site-specific, but they also need to be developed as information in respect of the site develops, and the more detailed assessment work, which is quite normally done post-consent, feeds into that.
Ms. Spence?
Well, after all this, I'm not entirely sure that the desperate position of someone who finds themselves without a water supply has been covered properly. There is no recognition that something would have to be done. These people would be homeless. They would still have to have a mortgage. They would still have to pay that in addition to rent or another mortgage. And this would be devastating for people who are put into this situation. And yet you haven't come up with any signs that you would enforce, for instance, the applicant to put them in a situation, albeit maybe in a different place, where they could continue their lives without penalties of a severe financial degree.
Sorry, David, you're on mute.
Sorry. Yes, Ms. Spence, I suppose the position would be, for all of these conditions, once we've heard everyone's evidence, it's going to be for us to go away and reflect on what we've got and reach a view on whether we, dealing only with conditions, how we think the set of conditions should be framed, and that's just going to be something we won't resolve today. It's something for us as reporters to go away and reflect on and incorporate into a report. So can I just move on to condition 11, which is the second last, I think, of the ones where Dr. Connor had made suggestions and have in this Crothway. So let me just, if you can go to that, please. So the first point Dr. Connor makes here is about water abstraction, which I think we just discussed, albeit briefly. So I don't need to go turn to that. The applicant says in response to, well, it says this does not seem like the right condition to address these concerns is to do with the external appearance of the substation compound. But then the applicant goes on to say, if the reporters feel that this is required, then the wording of the condition should be changed to state, include details of water supply and foul water disposal where proposed. So I'm just, it may be for you, Mr. Ennis, or from Sidrick, but you were warning against duplication and confusion, and you put that there as a suggestion, but I suppose my question back is, would that already be controlled by any of the other conditions? And if so, which one controls it already?
Yeah, I mean, I think we can say that it's anticipated that will be an unmanned substation, and therefore there's not going to be a significant requirement for water and things. In terms of projects, generally SPR use rainwater harvesting for grey water, so that's things like toilet flushing and things, and a borehole with treatment for potable supply. Now, that's their normal approach. I'm not saying it would definitely happen here, but that's the standard approach. And then typically surface water will drain into drainage ditches and go into the sort of the SUD system and things, and anything that's oily or the like would go through an inceptor and then drain through the settlement system. I don't believe the extra wording is required. I think that could be covered in condition 18, or is covered in condition 18. But if you, sir, felt it was necessary, then those additional words could be added.
Okay, that's fine. We can reflect on that. I was going to move on from this condition, Dr. Connor, if you're content to.
Yes, that's fine. I just had a short comment on condition 17, but apart from that, that's fine.
David, you're muting the wrong way.
Dr. Connor, apologies for the comedy performance. What were you going to tell me about 17?
Dr. Connor, you're on mute as well.
Sorry about that. I just wanted to say that these planning conditions can be really complex and very difficult to enforce for a local authority, particularly one that's short of staff and resource. And one of the recommendations that was made in the Whiteley decision notice, which the appellants lodged, which was CD 9.4, one of the recommendations from the reporter, which was 5.201, was that they recommended a planning monitoring officer, basically so that, you know, multiple planning conditions could be properly enforced. Whiteley 3 was only 5 by 111 metre turbine, so it's considerably smaller than this. So I think it is relevant, and I think it would be a big help for the council.
Okay, thank you. I was going to come on to 17 later, but I'll just ask that question now then, because it was quite a small point. So I think we noted and understand the parties' positions in respect of the proposal for a PMO. But as we put in the agenda, we wondered whether the role of ecological Clarker works to extend to PMO and covered by a single commission, or are they different roles which should remain separate? So I just wondered whether the council, firstly, and then the applicant had a view on that point.
Sorry, we can't hear you, Mr. Gibbon. Mr. McGibbon.
Can't hear you, Alistair.
I think he is. He has turned his mute button, but we're just not getting any signs.
Well, why don't I go to the applicant first then, and you can maybe see if there's a IT issue at your end, Mr. McGibbon. It might be something that Mr. Campbell would review on anyway, but from the applicant's point of view, I mean, we're not proposing this as a definite a proposition. It's just that we wondered whether there was duplication and the same person or firm or contract could do both.
Yes, I think they're quite clearly separate functions. Both of them are important functions. They're both very important in ensuring that conditions are complied with, but in slightly different ways. The role of the ECO relates to a lot of the things that are going on site, the construction works that are going on site. They are located on site. That I was going to say embedded with the team, but that's not quite right. They are located on site, and they are there to watch things as they're happening, see what's going on, and make sure that things are being followed in the correct manner. They also have a role in reporting certain matters back to the local authority and to the company, the developer, and they should have the ability to cease works on site or a particular set of works on site if there are environmental reasons for doing so. The PMO is a slightly different role, and it is one that is looking at the planning conditions and ensuring compliance with those conditions. Just in respect of the PMO, I'm sure you'll have spotted, but the applicant's position is that the PMO isn't required for the operational period, but that they are a valuable resource on it as part of the construction process and then also the decommissioning process at the end.
Okay, thank you very much. Mr. McGibbon, I don't know whether you'll be able to talk to us, and you might not have much to add to that, but over to you. Yeah, sorry, I can't hear you.
I'm sorry, I have no idea what he wants to say, otherwise I could help you.
Well, we can park it at the moment. If there's something pressing that you haven't had the chance to add, then you can let us know about this afterwards.
I'll phone him in the meantime and see if I can get some idea of what he's about.
Okay, thank you very much, Mr. Campbell. I'll give us a break, and we can do that shortly enough, I think. Okay, so that was 17. So, the final condition, I think, was that Dr. Connor was interested in was 4, which is serious incident reporting. And we had a question about this anyway, so that's good. So we can have a look at that. And this will be a section 36 condition rather than a planning condition. So I suppose firstly is the questions to the applicant. The council's suggestion is that it be notified of serious incidents, presumably as in addition to the government, the Scottish government, Scottish ministers, rather than as well as them. Does the applicant have an objection to that being a requirement?
Sir, as I understand it, this is a condition relates to the Section 36 application, consent, permissions, and it's to do with the Scottish Minister's monitoring of serious incidents and things. There is a requirement in the ECOW condition which requires the ECOW to report to the local authority, the local planning authority, and they're two separate things, but incidents would be reported in both ways.
Okay, thank you. We can take a closer look at that at the ECOW condition later. So, Dr. Connor, would that address your concern that there's a separate arrangement for the local authority to be informed of these things? I appreciate you also make the point about remediation measures, but in terms of that involves the council in the process.
Yes, I think as long as the council are copied in at the same time, then I think that covers the bases. I think the trouble with just notifying Scottish ministers is that it sort of goes into a bit of a morass and there's not really local accountability. So I think it's important that the local council are informed as well at the same time.
Okay, thank you. Yeah, I entirely understand that point. And so I suppose for the applicant, you mentioned the situation there, the ECOW condition. I suppose we were thinking of things like the construction environment management plan, the pollution prevention plan, and so forth. One would, am I right to assume that those would be likely to have protocols for reporting incidents and mitigation of them and so on, so that the council wouldn't be kept in the dark about incidents, not kept in the dark, but wouldn't be informed of incidents like that?
Indeed, I would expect a lot of the plans that are the subject of condition would have some sort of reporting requirement in them.
And what about during the operational period? I'm assuming that these conditions wouldn't generally cover that period, but one can imagine if a turbine needed to be replaced or repaired, there might be risk then. Do you have any thoughts on how that risk it presents itself and is controlled?
There is a condition that covers the removal of a turbine and things like that, so I would expect that to be covered there, any requirements relating to that. Can't recall the number off the top of my head, I'm afraid. It's condition 37, sir.
Okay, and just to go back to it, but the water quality management plan, that doesn't say anything about its duration in the condition. Is your would your expectation be that that plan would cover the operational period, or is it just for the construction period?
I would expect that not to cover the operational period. I would expect it to cover baseline monitoring, construction monitoring, and a limited amount of post-construction monitoring.
Sorry, Dr. Connor.
I just wanted to say that somewhere, because of the turbine maintenance that goes on, some of which requires, as I understand, and I'm happy to be corrected, but replacement, for example, of hydraulic fuel and hydraulic lubricants and so on to the nacelle under great pressure. So I think, you know, there is the potential for accidents to happen during the operational period, and for that reason, I think there has to be some mechanism such that there is a requirement to notify the council in particular.
Yeah, I was interested in that on that point. So if we have condition 4, which is serious incident reporting, and it endures for the duration of the consent, one assumes. Let's see. Yeah, it's a period of consent. So let's take an example of something like fuel or lubricant being spilled in that way in the course of maintenance. I suppose, firstly, for the applicant, is that the kind of serious incident that you'd expect to be reported to ministers? A fuel spill or something like that?
I'm not entirely sure where the reporting of a serious incident kicks in that regard, I'm afraid.
Well, yeah, could I just kick in? The position is that if you look at the condition 4, it's whether there's a breach of health and safety or environmental obligations. So therefore, it's not just whether there's, and it's throughout the whole consent. So the issue there is that effectively, because of this condition, you have to have provision in step to ensure that you're complying with health and safety and your environmental obligations, which are at law and which are ongoing and cover the activities that have been specifically mentioned. And it's in that respect that condition 4 kicks in. So if, for example, there is a spill, but you have all your contingency measures in place, and there is no breach of any environmental obligation, then there is no obligation to report. It's circumstances where your measures haven't worked and effectively you're either in breach of health and safety or environmental obligations, you have the duty to essentially report up to the Scottish Government relating to those matters. But I mean, the operation of this wind farm is subject to all the other controls, the environmental controls that we have in place. And it's, so all those matters, we're obliged to comply with the law, which is about discharge and all those matters. So in my submission, all that this is doing is telling you that if you break it, those provisions, you have got a whistleblowing obligation to the Scottish Government very early in the process. And what they're saying is that if you've had those things, it doesn't actually oblige you to do the remedial measures. You've got to say what you've done. So incident, breach of either health and safety or environmental obligations, what have you done and what are you doing to rectify the breach? And that's really how that kicks in. It's a sort of, essentially you have to be in a position, if you're operating a wind farm subject to this condition, to meet these requirements. So our operational plans will do so. And we know if these incidents occur, that there has to be a report up to Scottish Government. But it is against the threshold of a breach of safety, health and safety or environmental obligations. And of course, a lot of what we do is operationally to ensure that we will not breach environmental obligations, even if there's an incident, because that's what's planned for.
Okay, that's helpful. I suppose where I understand Dr. Connor's position to be is that, well, it would seem, put words in our mouth, if one tells the Scottish Government ministers about something like that, why wouldn't it be natural to tell South Ayrshire Council as well? Because an incident's occurred, it's gone above that threshold of a spill which you've maybe quickly mitigated. So it has a level of significance in as much as it's an event that has to be reported. Why not tell the council? Why not have an obligation to tell the council as well? I'm just put the question to you.
Yeah, I suppose the answer back is you could have a never-ending list of people who are on top of the Scottish Government. You might incorporate within that the Health and Safety Executive, all sorts of agencies, SEPA, SNH, etc. But the idea is that actually this is a duty to notify the Scottish Government. And no doubt, in terms of these matters, where agencies need to be involved, they would be notified, and because that would all be part of what measures we'd taken. I think the difficulty with saying it's just the council is that quite a lot of the council does not have a remit in enforcing health and safety. And in terms of most of the environmental obligations, there will be other agencies involved as well, potentially. But equally, I think one of the issues here is this is a Section 36 condition, and I think the government would probably want to keep that as a Section 36 condition of reporting to them. If there is going to be an alternative provision that the council have to be notified of similar terms, then I think it should probably be taken out of the Section 36 and incorporated within the planning deemed provisions.
Okay, Dr. Connor, did you want to come back on that?
Yeah, I just wanted to say that I detect a rather a reluctance to notify other people and the local council in particular. I don't think it's difficult. You can do a CC on an email quite easily. I don't think it's a big deal that is being made out. And I think for local people who are adjacent to this wind farm, it's important to them to know that their local authority know what's going on.
Okay, that's good. Thank you. That moves us away from the conditions which generally have been dealing with private water supplies and things related to them. So, the two or three conditions that we've got left to talk about was condition 6, which is about implementation in accordance with approved plans. Then condition 12 on micrositing, and a question on 21, which is about the traffic management plan. So I think the micrositing one will probably take the longest. It's probably a good time just to take a short break now. So if everyone's happy, can I suggest? Sorry, Mr. Campbell, carry on.
Can I just say that Mr. McGibbon wanted to come in on the planning monitoring officer condition, just to emphasise the importance of an independent person to the council at the present time, because resources are slender and the council may not be able to fulfil this function itself. It was really to endorse what we heard earlier. Excuse me, sorry.
Okay, that's fine. Thank you. And assuming you can hear me, Mr. McGibbon, that's fine. That's noted. Okay, let's. I'll give you slightly longer then. Let's resume at 4:05 then. If that's okay, everyone. Thank you very much. Have you sorted out your IT problems, Mr. McGibbon, or are you still incommunicado? Yeah, still can't hear you, I'm afraid. Sorry about all that.
Did you hear him, sir? I didn't hear him. No.
No, it's still can't hear, I'm afraid.
Still can't hear.
That's it now. Can hear you now.
Can you hear?
Yeah, you know, yeah.
Right. Sorry, I don't know what I've got computers and phones, so I don't know.
Excellent.
Okay, if everyone's ready to press on again, I said there was only 3 conditions, but I misled you. There's 4 I want to talk about, but hopefully they won't take us too long. The first one I'd like to take us to is 21, which is traffic management plan. This is hopefully the simplest question to get through, and as we put in the agenda, we'd simply wondered whether it might be a good idea to have South Ayrshire Council consult the Priest and Galloway Council when it discharges this condition, simply because some of the road traffic effects would be experienced in Priest and Galloway as well as in South Ayrshire. Mr. McGibbon, have you got now that you can speak to this, have you got a view on that?
Yeah, thanks, sir. Yeah, we wouldn't have a problem with that.
Okay, thank you. And does the applicant have a position on that?
I think in consultation with Dumfries and Galloway would be sensible. I've got one or two other little bits following on from some of the discussion yesterday in respect of traffic management and things. And I'm wondering that in the context of item F, in the list of matters to be covered, it would be sensible to make it clear that there should be details of all signage associated with private drives and tracks and lining arrangements which are required to be put in place prior to the commencement of development, to ensure that the signage issue that was discussed yesterday is covered off in a condition. And something related to that is to include a reference, part J, if you like, in the SEMP, which could refer to a project community and public relations plan, which would be the way in which it could be agreed that notification of contact numbers for the construction team or whatever it might be may move forwards. That could include reference to a press advertisement. It could include reference to a website, but the reference to a project and community public relations plan would allow that to be covered off as part of the SEMP. And by putting it in the SEMP, it would mean it applied to the construction as a whole and not just the traffic management issue. But clearly traffic related issues would be covered under it.
Okay, thank you for that. I think that addresses 21, just looking up, and yes, that touches on some of the matters we discussed with Ms. Spence and Mr. Andrews yesterday. Okay, if we can look then just at condition 1, which is about the duration of the consent. So I think we understand both where the council and the applicant are coming from. We just get it. So our condition, our question is a very simple one, Ms. Sidgwick. Are you aware whether or not ministers have ever consented a wind farm in perpetuity?
I'm not aware of a scheme having been consented in perpetuity, but I am aware of schemes being consented beyond the 25 years. An example of that is Paul's Hill, and the decision notice is document CD 9.23. You'll also note that in the case of Falago Rig, which is CD 9.20, it was extended out to 30 years from 25 years. And there are other examples of applications being considered and consented for lifetime extensions, an example of which is Dunlaw, and that would give it an operational lifetime of 34 years. In the case of Hare Hill, I understand there's a case of it being minded to approve subject to the agreement of a legal agreement, and that will take it out to an extension of 19 years beyond the original 25 years, so it would expire in 2041. There are one or two very early schemes in Ireland that have been consented in perpetuity. And of course, wind farms are almost unique in being consented with a time limit on them. Most other developments do not have such a restriction.
Okay, that's fine, thank you. So let me see. Just bear with me a second. Yes, so let's deal with 6 before we go on to micrositing, which is 12. So 6 is about implementation in accordance with approved plans. I just want to look at the council suggestion condition first. I think Mr. Campbell and Mr. Ennis might recall a similar, I think we had a similar conversation in the Borders about 3 years ago about this issue for another wind farm. But I'm just going to find it, and I just want to read out a little bit from it. So looking at the council suggestion then, and it's talking about except as otherwise required for the terms of this consent and the planning permission, development shall be undertaken in accordance with the application EIA report, proposed site in figure 3.1. But it also says, as supplemented or amended by any further or additional environmental information and other documentation lodged in support of the application. I suppose my understanding was that it's not thought good practice to define a consent in that way, because it's not clear what other environmental information in particular is referred to, and often much of that environmental information we have not really supplied for the purposes of control and consent. It can even be inconsistent, for example, if you have micrositing or other changes to a scheme. And so, there'll be numerous other conditions imposed and which require detailed information about what is to be constructed and how it's to be constructed. That all has to be submitted to and agreed by the council. And therefore, I just wonder whether a more general reference to environmental information, such as we see here, isn't necessary or could even be unhelpful. I just wondered whether the council had any thoughts on that issue.
Sorry, I didn't pick up every word you said there because of some fault in the signal. I think, though, that your question focuses on the underlined text. Is that right?
Yes, I'm sorry, Mr. Campbell. Yeah, it's just about the lack of the possible lack of precision and certainty. Yeah. Relying on a vast amount of environmental information, some of which might be consistent, not all of which has been provided for the purposes of controlling the consent. Yeah. In the context of having 40 or so other conditions which impose often quite very detailed requirements for the provision of information and the agreement of that information, my concern is this unnecessary? Is it even unhelpful?
Well, in our submission, it's unhelpful because it's imprecise and unenforceable. The concern arises, just as an example, from the development at Arecleoch, which is constructed where each of the turbines is between 50 and 70 meters from the location which was proposed in the environmental statement, as it was then called. Now, of course, there's a micrositing condition anyway, so some flexibility is anticipated. But what we have here is not only a condition which is presumably directed to turbine layout, but also may be reliant on other environmental information. Now, lawyers can argue all day and all night about whether something is environmental information or not. And for that reason, my simple point is the condition is too vague to be enforceable and therefore fails the test in circular. Were it to be confined to a reference to EIA report figure 3.1, then I think this condition would be unexceptional because it's also subject to micrositing possibilities if ground conditions dictate that.
Okay, yeah, I'm sorry, Mr. Campbell.
Sorry, Ms. Sidgwick will correct me if I'm wrong, but I think that the principal purpose of this condition is to try and fix turbine layout so that it's consistent with the other environmental information that we've already heard about landscape and visual impact, and not to allow too much of a deviation from that. Otherwise, you get a wind farm that looks different from the one that is consented. But Alison may correct me if I'm wrong. Same applies to tracks, of course.
Okay, thank you, Mr. Campbell. That was my fault. That wasn't abortive, but I took you initially to the wrong place. I was taking you to the terms of the condition, which you identify there. You think is too imprecise because of the same kind of things that I mentioned. But can we look at over the page at the SEC response of the 24th of December 2020 on the final column? Have you got that there? You see that?
Yes.
So right at the bottom of that.
Okay. Give me a second.
Right.
Well, the weasel words are in brackets in the second and third last lines, or rather, the second. There's only one word in the last line. It's really the last phrase. I absolutely, I'm sure the council officials would agree with me that the greater precision to be found there is very welcome. It's quite possible to import words which might make any variation, or as they call it here, supplement or amendment, dependent on the council's consent. The trouble is it's a section 36 case, and that would mean there's a conflict in jurisdiction. So our central point, just to put it quickly, is you need precision here, and with respect, you don't have it to a sufficient extent.
Okay. And on reflection, in that SEC response that I took you to, right at the bottom, it would be better still if you simply stopped after the word report. Is that what you're saying?
Yes, that's what I'm saying. Mr. McGibbon, I haven't discussed this with Mr. McGibbon, but no doubt he'll tell us if we can hear him. He can tell us if I'm wrong.
Sorry, after the words of after EIA report, is that what you're?
Yes.
Yes, sorry, to be clear, after the second time, so it's in the third last line, it says proposed site environmental impact assessment report. So you will have used figure 3.1, but then you will not have made the further qualification.
Yeah, because we're just described beforehand. Yeah.
Okay, I suppose the question for the applicant, you've got an alternative way of doing this with an appendix. So I suppose it's a similar question to the one I asked about duration. Has that approach? Are you aware of that approach having been followed in other Section 36 consents, and therefore ministers have presumably found it to be an appropriate approach if they have done so?
Yes, ministers have used that approach before. You'll find it in the decision notice for Paul's Hill, which is CD 22.9, and also in the Gordon Bush decision notice. Those were the two most recent ones I looked at that had it. The Gordon Bush decision is CD 17.4. In my experience, it is the standard approach from the Scottish ministers in respect of Section 36 applications, and has been for a little while.
Okay, thank you. We can take a look at those. So I think then that just leaves us with micrositing.
I'm sorry, could I come back a second?
Yep.
It may be worth underlining that neither in the Paul's Hill application or in the Gordon Bush application were there acute private water supply issues such as we find in this case. Gordon Bush is remote from population, and Paul's Hill didn't transgress any significant private water supplies so as to create an issue, not the same sort of issue we've had here. I think the council's position is pretty easy to understand, that precise positioning of the turbines where the overall site is, as we heard from the landscape and visual evidence, is a matter of controversy. That precise, if you make some findings about landscape and visual impact favourable to the applicant, they need to be made to stick to that, so that what they produce by way of a development corresponds to what was assessed in this inquiry. I don't think that's a very difficult point to understand.
Okay, thank you, Mr. Campbell. And it probably naturally takes us into condition 31 anyway, which is about micrositing. So
is it not condition 12?
I'm sorry, condition 12, I beg your pardon. It's been a long week. So I'd like to talk about specific restrictions that might or might not be appropriate for micrositing before we talk about the size or indeed existence of an allowance before the council has to okay something. So the condition which the applicant and the council agree on has two clauses, if you like, or it carves out two things from the micrositing ability. The first one is that council has to give approval if any turbine is desired to be sited closer to Leigh Corenzi. So I can understand clearly why this is desired for the turbines at the north part of the site, But I suppose I just wonder, is it necessary for all of them? Might it make more benign microsighting for some of the more southerly turbines a lengthier process than it need be? And should this condition just apply to some of the turbines? Sorry, I'll put that to the council first if you've got a view on it.
Thanks. I would say certainly to turbine 4, which is the one that's closest to we in Kilrenzy, that'd be a certainty. Need to look in. To be honest with you, that was the one that's kind of stood out, so we didn't consider any others. But certainly turbine 4 would strongly wouldn't want to move any closer to those properties.
Okay, thank you. And has the applicant got a view on this? I appreciate it's not really come up in discussions before, but.
Yes, sir. I think we would agree with that. It's turbine 4, which is the key one in the context of sensitivities and those properties.
Okay, thank you. It's a point we can reflect on. The second thing is water courses and retaining a 50-metre buffer when mapped at a 1 in 100,000 scale. Dr. Connor, sorry, I said that she hadn't no more concerns, but she did raise this as well. She was concerned that this doesn't take account of more minor water courses. So I wondered, is 1 to 100,000 scale standard practice, and maybe more importantly, does it hold good here? And I think in response, I think it was the applicant refers to the controlled activities regulations using 1 in 50,000. So I wondered if you're putting that down as a good practice, why propose a 1 in 100,000 here? I'm just trying to understand what the differences might be.
I think that the 1 in 100,000, I think is the standard wording from the ECU, and that is why we have suggested that.
Sorry, do you know if the mapping that's done in support of the ES for water courses is based on the 1 in 50,000 data set or 1 in 100,000 data set? I had a quick look and I couldn't really find confirmation either way, but and maybe it become apparent if I look more closely. But do you know what the position is?
I think it's standard practice for the SLR hydrology team who would have done that to agree it in the scoping report and then to set it out in the EIA report. And my understanding is that they used 50,000 mapping in the EIA.
So if Dr. Connor, you may want to come in a minute, but I'm just going to take this a little bit further. The condition says 1 in 100. If the impact assessment report and the work underlining it was done in 1 in 50,000, do you see a difficulty if that condition changes to refer to the 1 in 50,000 set rather than the 1 in 100,000 set?
Sorry, so was that a question to myself or to, yes, I think we can use 1 in 50,000.
Thank you very much. Dr. Connor, did you want to come in at this point?
It was just a very quick point to say that South Ayrshire Council's mapping of the water courses with the wind farm infrastructure was very much clearer to be able to see the relationship of the built elements, tracks, etc., than what was provided. So I think can't remember the scale on that, but something along those lines would be much easier.
Do you know, Dr. Connor, what document you're referring to there? It might be that somebody from council would be able to point me to it. Do you know where you saw that?
I think, I'm sure Ms. Loman will remember, but I think it was 14.6, CD 14.6, I think.
If it's the mapping that we sent through, it's 1 to 15,000, or 1 to 15,500 actually. When I go out on site visits, I usually carry a 1 to 25,000 map, which gives a much better definition of the land and the layout, the topography and terrain, if that's any good.
No, that's helpful, Ms. Lobbin. So is that right then? You said 1 to 15,000, but that would be in 14.6, or it's anyway, it's in the council's area.
I'm assuming that's. I don't have your numbering. I'm afraid I only have 1 or 2 things in that number, and the rest is all hard copies. But the map, the interactive map that was sent through, and then the copies of that map that were sent out to those that didn't get the interactive map, it's 1 to 15,500. So it gives great detail. It's a much greater detail. And it gives your landforms and gives your topography very clearly in relation to properties or other structures or things on the land, such as water or lochs or rocky outcrops, etc.
Okay, fine, thank you. Yeah, I think I can remember what we're talking about now. Okay, I want to move on. Just we suggested some things, I think, for discussion. I have seen when micrositing conditions that also place a restriction on the ability to microsite a turbine without recourse to the council, without making it higher or making it a metre higher, for example. And I wondered whether, as I say, we'll come on to the kind of envelope later, but to the council, is that something which you think would be necessary here? That let's say beyond moving a turbine a metre higher up a slope, the council would need to approve that, or some other number. I'm just speculating.
I'd say it's maybe not necessarily to do with the height, it's to do with the position, the located can have the impact. So it's certainly if something's going to be higher, then yeah, the council would want to be notified. But as I say, moving it as well can have as bigger impact than making something slightly higher. Depends on its location.
Yeah, okay, and I'll Ms. Crosby, I'll let you in a minute. Yeah, we'll come on to the location in terms of lateral distances in anything. Ms. Crosby, do you want to come in there?
Thank you, sir. I just wanted to mention what was discussed yesterday by Mr. Duncan about micrositing and peat, and that he said that the positions at the moment are the best positions and that there really wasn't much room for micrositing. And he particularly, I think, I'm not sure whether it was you, sir, or whether it was Mr. Duncan who referred to turbine 5713 in particular, that there was very little room for manoeuvre.
I think I'd asked the question of Mr. Duncan based on the map in relation to one of the peat reports, that on the scale that was shown, it looked as if those turbines were close to areas of peat that were greater than 1 metre, which was the depth that H.R. Scott had indicated that they shouldn't, that they wouldn't like to see them go beyond. So that was the context.
Well, I'll come on to Pete in a moment. Thank you. So, just an elevation then, Ms. Sidgwick. As I mentioned, I've seen elsewhere this being a requirement. Is there anything about this site and this proposal which makes that appropriate or not in terms of a restriction in micrositing.
You're quite correct, sir. There are some sites do have a sort of vertical micrositing requirement, if you like. It tends to be sites that are very ridge-like and things where the movement of a turbine is a relatively small distance can increase its elevation quite significantly. This is actually quite a flat site. It's not completely flat, but if you look at the slope plan, which is contained in CD 1.5 figure 10.1, TA, Technical Appendix 10.1, figure 10.1.6, you can see that it is actually a relatively flat site. There are areas of pale blue and green, which are the flatter areas, and then yellows and reds getting steeper. You can see that a lot of the turbines have been placed on relatively flat land. So in the case of this site, I'm not sure it is required because of the sort of geography of the site, if you like. If there is a concern about sort of some of the particularly sensitive areas, we heard discussion in the context of the landscape session from visibility from the north, and therefore if you were going to restrict elevational micrositing, if you like, I would suggest it would be appropriate to just restrict it to turbines 1 to 4 if you believed it was required.
Okay, thank you. What about? Well, actually, let's deal with it now. The other, no, in fact, let's do peat first. The other, I've also seen micrositing, I think, which says not into an area of peat or not into an area of peat greater than 1 metre depth. Again, Ms. Sidgwick, if you get, we don't put forward this as a preposition, but if you get any views on need or appropriateness for something like that here.
A couple of things to say on this. I think when Mr. Duncan was talking, he was referring to the fact that at the moment he believes, with the information that is currently available, the turbines are sited in the best possible location. I think it's important to remember the purpose of micrositing, and that is very much to allow a degree of flexibility on the site with all the details there, and quite often it is sort of with the construction team looking at it and things. And the whole purpose of it is to minimise any environmental impact. And if when the team get out and look at it on the ground and they realise by moving it 2 metres this way or 10 metres that way, they can reduce the amount of peat or whatever, then it gives them the flexibility to do that. It's not going to be in the best interest environmentally to go into an area of deeper peat, and the ECAI would be party to those discussions, and they are part of that decision-making process. So in my experience, an ECAI wouldn't be sanctioning the movement of a turbine location into an area of deeper peat. They are balancing up a large number of issues. There may be an ecological issue that they're taking into account. There may be various other matters they're taking into account, and they're looking for the most environmentally acceptable solution on the ground.
Okay, that's fine. If the council got a view on that particular point about peat?
Nothing to add really to what Sedgwick stated there.
Okay, and the next thing that we speculated upon, I think, was private water supplies, and how should micrositing, not sure how should micrositing take account of them, but what, if anything, should this condition say about micrositing and private water supplies? Dr. Connor, have you got a view on this?
Well, as ever. My concern are there are different soils mapped on the site, some of which are particularly more permeable than other soils. And without actually understanding where the groundwater is feeding into dependent private water supplies, it's difficult to know whether the micrositing onto those soils would actually produce an effect downstream. We've had a lot of discussion about the concentration of built elements within the crosswater catchment. And I think, well, that's where more than 50% of the turbines are. And I think just moving them anywhere near any of the tributaries, because of the concentration of built elements, cable trenches, etc., may have unintended consequences. But I don't know quite how you predict that, given the concentration that's there already. We already have a situation where there is, in the planning, in the mapping of an access road that's within 50 metres of a tributary, one of the tributaries. I don't think it's actually the crosswater, but it is within 50 metres of a water body. It may be something that would be better microsited away, but there may be other elements like peat to take into consideration. That's listed in chapter 10. It's something like 4.1.1.1.1. Oh, and I found the reference for South Ayrshire's map. It's CD 16.8.
Okay, thank you for that. Does the applicant have any? Obviously, we've talked about water courses in terms of the 100,000 versus 50,000 mapping, but on the particular issue of private water supplies and Dr. Connor's thoughts there, does the applicant have anything to add to that?
I think so. I mean, I believe it's covered by Part B of the draft condition, saying that there would be no moving any closer than 50 metres of a watercourse. That's the standard wording. I'm not aware of a decision that includes private water supplies as part of the micrositing. But as Dr. Connor says, there is an environmental balance which will be discussed and considered at the time.
Okay. So that's fine. I want to just talk about Mr. McGibbon. You said that it was moving the turbine laterally that can have more significance. And again, I've seen plenty of wind farm consents where 50 metres micrositing allowance has been given, subject to these kind of additional layers of constraint that we've been talking about. The council says in its evidence that 30 metres is conventional. Do you mean that that's what you usually allow for in the council's consents rather than being conventional in a more general sense?
From my understanding, I think that's from the council rather than more general. I need to clarify that, to be honest with you.
I think, to be fair, sir, the 30 metres might be my drafting, not Mr. McGibbon's. I drafted these responses, and so it's based, I guess it's based on experience.
Okay, so that would be 30 metres based on your own experience, Mr. Campbell.
Well, yes. I mean, I'm not saying there have been no exceptions, and I don't wish to give evidence in the inquiry, but you asked Mr. McGibbon where the figure came from, and I think, from memory, I drafted this, and I think that figure comes from my experience, yes.
Okay, that's fine. And Ms. Sidgwick, in yours?
I've seen a variety, sir, over the years. I've seen it as high as 100 metres. I would observe that Arecleoch and Arecleoch both have 50 metres microsighting in their conditions.
And is there anything in this site, on this site, Ms. Sidgwick, that would make you think that 50 metres isn't appropriate here?
I think 50 metres on this site makes sense. It allows a degree of flexibility, and it ought to be a sufficient working area for them.
Okay, I'm happy to move on from that unless there's any further final comments on microsighting. Okay, so that in fact takes us to the end of our questions on conditions. But I just want to see if there's any other final points on conditions which anyone feels need to make before we end the session. Is there anything from anyone? Mr. Ennis.
Yes, thank you, sir. Just in terms of condition 5 was put forward as our aviation lighting landscape and visual impact mitigation plan. And insofar as we put forward that condition, I understand that some doubt has been cast by Mr. Stevenson on the deliverability, the potential deliverability of the aircraft detection lighting system, which we put in as one of those options. This afternoon, we have obviously submitted a document CD 1526, which is the Cirrus report, which considers the whole question of aviation lighting in a might say in a more strategic context, considering the likely future regulation of aviation and flying, and considering it against the potential available technologies that are likely to come forward in relation to potentially utilizing that also to offer mitigation subsequently to the whole question of how much time the aviation lighting has to be on in certain parts of the country. And in that respect, given that position taken by Mr. Stevenson, I just wanted to make sure that you understood that where we come from in terms of putting forward this condition is on the basis that the technology is already available and the transition in relation to various matters relating to the aviation sector is already in train in relation to potentially requiring electronic conspicuity in relation to aircraft. So I've got two people here and they both come from a slightly different perspective. But if you need further clarification, I was just going to explain who they are and their roles, and then you can see whether you want any information from them. The first is Anne Mackenzie, who is Scottish Power Renewables Senior Aviation Manager. She previously worked in the aviation sector, but came to join SPR in 2011, and really focuses on the whole relationship between wind farm development and the aviation sector, both in the UK, and has also got responsibilities in Europe as well. And from that, she's one of the most experienced people in relation to that whole relationship, and sits on the BAE's Aviation Management Board, the Scottish Government's Aviation 2030 Task Force, the Air Defence Task of the MOD, the Renewable UK Aviation Working Group, and the Wind Europe Aviation Task Force. So she has been at the forefront of trying to make sure that wind farms can operate effectively, having regard to various aviation interests. And she obviously has a vast degree of experience in these matters, including some of the aviation lighting that was referenced in the inquiry session. I've also got the author of CD 1526 here, Mr. John van Hoosgraten, and he is the operations director at Cirrus, and he's got 30 years experience in air traffic control and air traffic management, and he specialises in advising the aviation sector in relation to regulatory and management. And he was the one who essentially authored and has taken forward the consideration of the Cirrus report CD 1526, which made a very clear finding as to where the likely direction of travel was that would deliver a sustainable long-term solution to the potential issues associated with turbines over 150 metres in parts of the UK, and provides a coherent recommendation ultimately for a strategy. And that is ultimately what we've reflected as one of the options going forward in the condition. Now, insofar as that, I'd be quite happy if you've got any aspects that you want to ask about where we are with the technology, or the deliverability, or indeed the fact that what is the direction of travel in terms of planes, electronic conspicuity, and in particular of this particular aspect, it's night flying that's relevant. And again, there's special rules with night flying and who's able to do it, etc., etc. And it does give us a vision that this is a very realistic option. And I don't know if you'd want to briefly hear where that's at the moment from perhaps Anne Mackenzie.
I'm sorry to disappoint you, Mr. Innes, to a certain extent. If we're here to talk about the terms of the condition, then, to be quite honest, we don't have any questions about it. I mean, Mr. Stevenson has given his views on it. We had that discussion in that hearing session, as far as it went. But to be honest, we've nothing to ask about the condition. So I think I'm happy to leave it at that. And despite the effort you've gone to today. Okay, that brings us to the end.
I think Dr. Connor has a question about this.
Beg your pardon, Dr. Connor.
I think nothing at all to do with aviation. It was just to do with water, private water supply and groundwater monitoring arrangements. Just to ask that at the moment there isn't a scheme of monitoring for private water supplies. I am aware that it is something that needs to be agreed with the local council, not with SEPA, who don't have responsibility for private water supply monitoring schemes. I think because this is not like your average private water supply monitoring in terms of the activity and the source, it would be better if all private water supply monitored according to the parameters set out by the Drinking Water Quality Regulator for the 2017 regulations. So in other words, not to make a differentiation between those that have business supplies or commercial use and those which are not commercial use. And the second part of that was also in terms of the groundwater monitoring parameters, which also need to be fairly extensive, so that they're able to pick up really the risk elements which may then impact on boreholes at a later date. That's all I was going to say. You'll be glad to know.
No, that's absolutely fine. Okay, before we, well, two things. Firstly, thank you everyone for. Sorry, Ms. Sidgwick.
Sorry, I've got one thing, and it's just in the context of condition 29, which is the bat mitigation and monitoring. There was some discussion yesterday, you'll recall, about whether or not there had been sniffer dogs monitoring at the existing Arecleoch and Kilgallia schemes. My understanding is that there isn't a condition requiring operational monitoring at either of those locations, but that Scottish Power have had sniffer dogs in the area, in those wind farm sites, doing their own monitoring for their own purposes. And I'm assuming in the context of that condition that you'll add in that the mitigation and monitoring plan would need to be implemented in full.
Is that one of the questions that we put, but we just haven't put it on the agenda? Yeah.
I think it was one of your questions from the middle of December.
Yeah, that's fine. That we just didn't think it needed further discussion, but that was noted. Yeah. Okay. So if looking at everyone, if that's the final comments, then that's great. Thank you all for your contributions today. Before we close the meeting, though, since Ms. Spence and Ms. Croftway are here, next week it's noise, just involving those. Alison, sorry, do you want to come in on that?
Yeah, I've got a few questions about the noise, if you don't mind me taking over for this. So yeah, the noise inquiry will take place starting on Tuesday at 10 o'clock. So we've sent out joining instructions today, so you should have that. Ms. Crosswaite and Ms. Spence will need you to forward those on to your the other parties attending on your behalf. Now, we also think yesterday we sent out an email in response to Ms. Crosswaite's suggestion about changing the running order. I don't think we've had a response from the applicant. I don't know whether Mr. Innes can respond on that.
Yes, thank you, Madam. Yes, the applicants are perfectly content with that change to the running order. Thank you.
Right, that's it. So we'll proceed on that basis then, which would be Ms. Spence, you going first with Dr. Armstrong, and then followed by Ms. Crosswaite and her witnesses. Can I just ask, is Mr. Grosvenor acting as advocate for you as well, Ms. Spence, in terms of leading your examination chief, or are you doing that yourself? Sorry, I didn't quite catch that. No, your microphone was on. Go.
Yeah. Grifter is going.
Right. Okay. So he's going to act as an advocate to lead your examination chief as well. And do we know, is Dr. Armstrong just going to read her statement? Is that the intention?
I think she's to answer questions. If people want to ask, and Greg might want to ask us some questions as well.
Okay, and the applicant would be able to ask questions and cross-examination of all of you, and we may have questions too. That's helpful, just helps everybody prepare. Also, just a reminder that document lists should be in by 3 o'clock on Monday, circulated to all parties. And any matters on the noise conditions we'll deal with at the inquiry. Obviously, we haven't dealt with those today because we haven't had the evidence on noise yet. Any other questions about next week's proceedings?
Just to say that the council won't be taking part, but it'll be keeping a watching brief on the proceedings. That's all.
Okay. Good to know you're keeping an eye on us, Mr. Campbell.
Thank you very much. Yes, that's all fine.
Okay, I'll hand back to David then.
Okay, I'm not sure I have anything left to do. Let me just check. No, that's it. I was going to ask, you picked up all those things on for next week. Well, again, then I'll close the meeting with another thank you, and I hope everyone can enjoy the weekend despite the weather. Thank you all very much.